Seder.
The destiny of America is always safer in the hands of the people than in the conference rooms of any elite.
Sam Seder.
They are unanimous in their hate for me, and I welcome their hatred.
We must guard against the acquisition of unwarranted influence, whether sought or unsought, by the military-industrial complex.
The Majority Report with Sam Seder.
Ever get the feeling you've been cheated?
It is Tuesday, December 6th, 2022. My name is Sam Seder. This is the 5-time award-winning Majority Report. We are broadcasting live steps from the industrially ravaged Gowanus Canal in the heartland of America, downtown Brooklyn, USA. On the program today, Mark Joseph Stern, senior writer at Slate. On the case that was argued yesterday, the next version of the won't make a gay wedding cake saga, and the case that'll be argued tomorrow in an attempt to basically say Republican legislatures can do whatever they want with federal elections. Also on the program today, Georgia runoff. Democrats look to reach 51 seats in the Senate. Meanwhile, Ukraine hitting air bases in Russian territory, hundreds of miles deep into Russia, via drones. Kevin McCarthy joins the Vote No, Hope Yes caucus on the debt ceiling fight. The Fed to approve a half-a-point rate increase this month, despite the fact that inflation seems to be easing, unclear about next year. And now even some railway shareholders are pressing for paid sick leave. Dreamers for border money deal being worked out in the Senate. Progressives, meanwhile, are lining up to vote against the National Defense Authorization Bill if it includes Manchin's side deal. North Carolina blackouts continue. No new info. However, Proud Boys and other conservatives have attacked drag events in 4 states over the past couple of days. Lastly, the Biden administration expands temporary protected status for over 100,000 Haitians. All this and more on today's Majority Report. Welcome, ladies and gentlemen. Thanks for joining us. It is Tuesday, or as my co-host Emma Vigeland calls it,
Tuesday Newsday.
There you go. Even though we're sort of doing news, but we're these are pretty big Supreme Court questions that are in front of the court over the past couple of days, and so we brought in someone who has some more expertise on that.
I'm looking forward to that because it looks like the court's going to side once again with people wanting to refuse to serve service to gay people. So, I mean, we'll see.
Just call them balls and strikes.
Just call them balls and strikes, of course. Yes, and we have a couple of clips that sort of bring that out. We will get to that shortly. But first, let's get right into what's happening with Kevin McCarthy. Kevin McCarthy's in a big fight for his leadership position in the House. He wants to be Speaker of the House. It appears that he will be. But there are at least 30 Republicans who will go on record and talk about what they're demanding in terms of the debt ceiling. Now, the debt ceiling is, just to remind people, the debt ceiling is this is sort of like the appendix of the U.S. governing body. We don't need it. It is the vestige of something it's just all pro forma. And when we spend in this country, we do so, at least our government, by coming up with a budget and passing a budget. But then at one point at the end of the year, we have borrowed money and we just have to authorize the Treasury to essentially borrow more money if we can't cover how much we've paid. Now, we always want a deficit, frankly, because that a government deficit means that there's a surplus in the private sector. So we would be very nervous if we had no deficit. We would start to see a recession. With that said, we've already spent the money. This is just an authorization to pay any bills that exist. If we do not raise the debt ceiling, we default on our debt obligation for the first time in the history of the country. No one who is in office presumably wants that to happen.
So it's like saying, I need to, tighten my belt, and so I'm going to stop paying this American Express bill.
Exactly. Exactly.
There you go.
Exactly. And there's a lot of people who pretend that they don't want to pay the debt, and so they'll vote no on raising it, but are secretly pleading with the gods that this doesn't get struck down. They just want the appearance that they voted against it and don't actually want it to be voted down because they know that it would be catastrophic for the economy. So that's the game that they play. Kevin McCarthy has to play that same game because there are at least 30 Republicans who have already spoken to CNN on the record of saying that, they are against the debt ceiling as is unless they get some type of something back for it.
That's the value as a leverage point.
As a leverage point. And to be clear, the reason why Republicans are able to do this and Democrats aren't are two things. One, there are at least, like I say, 30 Republicans who are willing to do this. There's probably more. CNN's not aware of each one, and I don't think they're going around to all 250 or 220. But there's 30. That's a lot. And on top of this, the Republicans don't really care about the implications of this in the way that Democrats do, because Democrats, broadly speaking, want government to function for the people. It doesn't necessarily mean that they want government to function in the same way that we would like it to function. Doesn't mean that they're willing to do as many things with the government. But broadly, Republicans don't want government to exist but for all of the national security and state power apparatus. So that's the dynamic here. Here is Kevin McCarthy on with Laura Ingraham, making it seem like he is one of those members of the vote no, hope yes caucus.
But this omnibus thing takes away your power for 10 months. You will have no effect on these critical issues. Zero.
We're 28 days away from Republicans having the gavel. We would be stronger in every negotiation. So any Republican that's out there trying to work with them is wrong.
So that
why wouldn't you
Mitch
wait with
McConnell?
the
Oh, pause it. Incidentally, I wanted to 4 days ago. Was it 4 days ago? Was it Friday? Kevin McCarthy went to the White House with McConnell and was it with Pelosi and Schumer, and there may have been one other folks there, and had agreed on how they were going to operate going forward. And of course, there's a huge right-wing apparatus, and he's got, like I say, at least 30, probably closer to 50 members of the Freedom Caucus, they used to call themselves, in the House, and he immediately gets disciplined as soon as he comes out of there. This is what is known as a weak leader. And here he is on Laura Ingraham's show, basically talking to Kevin McCarthy from last Friday and to Mitch McConnell. Go back.
Republicans having the
Go back a
gavel.
little bit.
We would be.
But this omnibus thing takes away your power for 10 months. You will have no effect on these critical issues. Zero.
We're 28 days away from Republicans having the gavel. We would be stronger in every negotiation. So any Republican that's out there trying to work with them is wrong.
So that
why
includes
wouldn't you
Mitch
wait with the
McConnell?
hand
Does that
stronger?
include McConnell?
Yes. Why would you want to work on anything if we have the gavel inside Congress?
You just
we
won
have a
the
stronger.
House.
Yes. Wait till we're in charge. I told the president, if we don't have a lifting of the vaccine, I'll do it in January. There's no. I told the Secretary of Defense. He had him call me just Sunday night.
But don't.
That's what Hillary Clinton called a public position and a private position. Remember?
Yes, and he's the vaccine thing is apparently the Secretary of Defense has said we need military readiness. We're going to maintain the COVID vaccine as part of the suite of mandatory vaccinations that we have.
Is that a real big popular issue? Like, let the troops not be vaccinated?
None of their issues are real big popular issues. No. This is a minoritarian party, but they have cultivated the craziest of the crazies to within their party. Donald Trump is their sort of titular leader, and this is all, and they all have to chase this, and so that's why he's saying it. But
they want to act like Trump in public and then save the economy in private.
Well, let's hope in private. I mean, but this guy's not necessarily the most. He doesn't have necessarily the mental acuity that one might want for someone to be sort of walking this high wire act he's doing. So
the adults are in charge.
Let's hope. We'll be talking to Mark Joseph Stern in just a moment. But first, we had what was it last week? Someone on from Give Directly, and Give Directly is a charity that I came across years ago during this time of year when we were advertising for a site called Give Well. And GiveWell.org has free research and recommendations about charities that can save or improve lives the most per dollar. This is really, really a helpful service, and it's free. You head over to GiveWell.org, and you'll see right at the top, like they have top charities. You can also search other charities, and they basically, you go through the various charities where they have done the research and found dollar for dollar, it is the most effective. It can range from, cash incentives for vaccines or vitamins or just various charities. And this is really important because you want your dollars to go to a charity where the most amount of money reaches people and in the most effective way. GiveWell spends over 30 hours each year researching charitable organizations. They only direct funding to a few of the highest impact, evidence-based opportunities they found. Over 100,000 donors have used GiveWell to donate to more than $1 billion. Rigorous evidence suggests that these donations will save over 150,000 lives and improve the lives of millions. And using GiveWell's research is free. GiveWell wants as many donors as possible to make informed decisions about high-impact giving. They publish all of their research and recommendations on their site for free. No sign-up is required. They allocate your tax-deductible donation to the charity or fund you choose without taking a cut. This is what's so great about GiveWell.org. Like I say, I found Give Directly through them. No relationship other than the give part. But I give through Give Well because they get funded to do what they do. The charities get the money that they need without having to lose any of that money that you donate. It goes directly there. And they're able to go to other donors to get money to fund their research, which is really helpful because, different people have attachment to different issues, and one will speak to them more. This is what we do for Hanukkah in my house. We go to GiveWell.org, and my kids pick out a couple of charities, and there's one night where our presents go towards giving charity. That's what we do. If you've never donated to GiveWell's recommended charities before, you can have your donation matched up to $100 before the end of the year, so long as matching funds last. So to claim your match, go to GiveWell.org, pick podcast, enter the Majority Report with Sam Seder at checkout. Make sure that they know that you heard about GiveWell from the Majority Report with Sam Seder, and then you get your donation matched up to $100. So you can double the value of your gift to whichever charity you pick via these guys. And It's a great service. Check it out. Great time of year for that. Also, another sponsor today. Have you been naughty or nice this year? Well, I don't want to know.
Oh.
But your internet provider does. They've seen all of your naughty searches.
Ooh.
Yep.
Wow.
But that's your business. That's why this holiday season, gift yourself the gift of privacy with ExpressVPN. Private mode doesn't keep your activity private. Your internet provider can see all the websites you've clicked on, how much time you've spent on them, and they've likely sold it to advertisers.
Oh my God.
Yes. They everywhere they can scrape data, they will scrape data. That's it. Bottom line. And listen, that's the best case scenario. We don't know how they're going to be using that data in a year from now, in 2 years from now, and 5 years from now. But with ExpressVPN, all of your traffic gets rerouted through an encrypted server, so all of your browsing activity actually stays private. ExpressVPN apps works on all your devices. Doesn't matter whether you're on your phone or your iPad or your tablet or your laptop or your computer, whatever, it doesn't matter. ExpressVPN, super easy to use. All you got to do, you get the app on your phone, tap one button, and you forget about it. You don't even think about it. You won't even notice the difference, except for your ISP provider will not know what you've been up to. Check it out. It is so easy to do for yourself. And like I say, privacy for now and for the future, because you really don't know how this data is going to be used down the road. Take yourself off the naughty list with the #1 rated VPN. Visit expressvpn.com/majority. Get 3 extra months for free. That's expressvpn.com/majority. expressvpn.com/majority. And lastly, if you run a business, you're probably a little busy this time of year on your website. Well, if you want to supercharge your knowledge of sales that you're making, you want to be able to integrate what you're selling offline and online, Shopify is the all-in-one commerce platform to start, run, and grow your business. Shopify gives entrepreneurs the resources that was once reserved for big businesses. So it doesn't matter if you're an upstart or a startup or an established business alike, you can sell everywhere. You can synchronize, like I say, your online and in-person sales and stay effortlessly informed. Shopify powers millions of businesses from first sale to full scale. Like, for instance, the Majority Report merch store.
Very nice.
It's just a little side hustle I got going. But the beauty of it is it's just simply easy to run. And it's totally scalable for big businesses. You can reach customers online and across social networks with their ever-growing suite of channel integrations and apps, including Facebook, Instagram, TikTok, Pinterest. People still do that on Pinterest? I do. There you go. And more. So you can gain insights as you grow with detailed reporting of conversion rates, profit margins, and beyond from all of those locations, including IRL, which means in real life. It's more than a store. Shopify grows with you. This is possibility powered by Shopify. Go to shopify.com/majority. That's all lowercase. Shopify.com/majority for a free 14-day trial and get full access to Shopify's entire suite of features. Grow your business with Shopify today. Go to shopify.com/majority right now. shopify.com/majority. Check it out. All of these links will be in the YouTube and the podcast descriptions. We're going to take a quick break. When we come back, Mark Joseph Stern, senior writer at Slate. We are back. Sam Seder, Emma Vigland on the Majority Report. Joining the show, coming back to the show, Mark Joseph Stern, senior writer at Slate, to talk about really two cases at the Supreme Court, which are actually bookmarking us. One was heard yesterday. These, of course, will be decided in June of next year or so, or at least we'll be aware of what their decision, June, maybe July. But yesterday, there was a case argued in front of the Supreme Court. Tomorrow, there'll be a case argued in front of the Supreme Court. Let's start with yesterday's 303 Creative versus Elenis. Mark, tell us about this case.
Yeah, so this is the case about a Colorado website designer who sued in federal court because she does not want to make websites for same-sex couples who are getting married. No wedding websites for same-sex couples. And she claims that she has a First Amendment free speech right to refuse to serve any same-sex couples who come to her and ask for a wedding website. Now, a twist here.
Let me just one thing.
Okay.
She doesn't have to do any of this. What she wants to do is have a business licensed by the state, use the state's apparatus to exchange funds and everything that's involved in that. She wants to use our resources as a society and engage in commercial activity, which is licensed by the state, and decide not to serve specific people, right?
Even though that situation has never actually come up for her, by the way, we should point that out, that she hasn't been asked to do a gay person's wedding website.
Oh, she will be soon. But I mean, that's the point ultimately, right? I mean, is that nobody's forcing her to do anything. It's just that there is, in the same way that, I have to obey the laws of the road if I'm going to drive. She's got to obey the laws of this country if she's going to use the country's apparatus to make money.
Right. So I think that's true on two levels. First, as Emma noted, no one has ever asked her to make a wedding website, let alone a same-sex couple. So this whole thing is theoretical. No one is forcing her to do anything, period, because she mostly makes websites for local Republican politicians and dog breeders. But to your point, Sam, yes, this is an important distinction that gets lost in the case. Colorado conceded time and again that if this individual were a freelancer or a contractor, or she lent out her services on a client-by-client basis, someone like Annie Leibovitz would come to mind as an example of that kind of artist, then they could discriminate against anybody. It's totally fine for them to say, I won't serve gay people, I won't serve black people, whatever. But once you open a business and you are presenting yourself as a for-profit company to the public, at that point, Colorado law kicks in, and you can't turn away people on the basis of their identity.
And this is not any different from having a restaurant and saying, not going to serve Italians, right? I mean, is it?
So on some level, I think you're right. And I think that is the correct level. At the end of the day, there's no difference between a website designer turning away gay people and a restaurant turning away Italians or whatever, because they're both acts of discrimination on the basis of identity. This individual...
Protected identity.
Yes. We love the Italians. They are definitely a protected ethnicity. This individual, Lori Smith, who makes the websites, she says that she's not discriminating on the basis of identity, that she's only discriminating on the basis of message because she does not want to express her support for same-sex marriage, which takes this out of the realm of a restaurant discrimination case where you can imagine a server saying, well, I don't want to express my support for Italians by serving them spaghetti and meatballs. She thinks that it's totally different when you're talking about a website design. But, and this is another kind of layer that I hope we can keep at top of mind, she has never actually been told by the state of Colorado that she has to create wedding websites for same-sex couples. What Colorado told her is that if she creates templates for websites, if she creates a wedding website template that she sells to different clients and customers, that she has to make that template available to gay people. So after she has actually created the artistic product, only then does Colorado say, okay, now you have to sell that product to all comers equally. And she is saying that even that violates her freedom of speech because simply selling this template will involve compelled expression in support of same-sex marriage. And I think that's a really dumb argument, and I don't think it's any stronger than a server saying they won't serve Italian spaghetti and meatballs.
Well, that's the point. It's like, I'm serving food. I mean, of course, it's, if I own a restaurant, it's an act of love and or it's not. Like, I mean, I'm giving it to the people as they come in. If I'm going to offer it to the public, this is a restaurant where we serve you food. I don't get to choose who is a legitimate eater of that food when they come in based upon, race or sexual orientation or, religious belief that the Supreme Court has already ruled on. It seems to me like even the idea of saying at this juncture, marriage equality or like same-sex marriage, that's done. There's marriage. Like we didn't have to say, we don't say, opposite sex marriage. Like it's marriage at this point. That is we have already spoken as a society. It is no longer controversial. Seems to me that like if she had argued, 15 years ago, I'm not doing a gay wedding website because there's no such thing as gay wedding. Like there's no gay marriage in this country, but now there is. And so it's just marriage. It's just a wedding. If you're doing a wedding, you're doing a wedding.
So Lori Smith and her lawyers refer to same-sex marriages as false marriages. They say that they do not acknowledge or accept the existence of marriages between two people of the same sex. And so even working with same-sex couples as clients, even to the point of simply selling them a template for a wedding website, that would require her to speak in support of false marriages that violate her religious beliefs.
If I belonged to a religion that did not believe in the Supreme Court, could I like, I'm sorry, guys, like I don't fake court.
Well, I think you should certainly try because that would make an interesting test case. But I think if we take a step back, like your question points to the broader issue here, which is that there are certain rights and certain groups that the Supreme Court clearly favors over others, right? Like if this were a case of a Muslim business turning away a Christian customer, we would not be here. It wouldn't have reached the Supreme Court in the first place. This is not really about a broad, neutral principle of freedom of speech. And I think that if you just scratch the surface of this case, that becomes so obvious because of the way it's argued. It is argued along the lines of Christian orthodoxy to give Christians a kind of get out of civil rights law free card and exempt themselves from non-discrimination rules by simply saying that engaging in some kind of business transaction constitutes a violation of their free expression because they're expressing support for some identity or whatever. And that, again, is a really dangerous argument because, as you pointed out, it just goes so far beyond a wedding website. It goes far beyond anything we recognize as speech, and it could encompass the baker, the florist, the restaurant, the venue owner. Pretty much anyone who sells anything could try to use this claim to discriminate against gay people or other people, interracial couples, interfaith couples, whatever. There's no limiting principle.
Well, Alito
let's do this with KBJ for a second because she made this point because, it was a religious tenet not that long ago, probably in some circles, still a religious tenet that black people and white people should not commingle, at least in terms of marriage. And then slavery was also justified on religious grounds. Here is KBJ trying to sort of like bring out sort of this dynamic. She is speaking to Kristen Wagoner. She's the attorney for 303 Creative, not the eternity. All right, let's play this.
So I'm sorry. Can I ask you a hypothetical that just sort of helps me to flesh that out? Because I also heard you suggest earlier that there's something different about race. Maybe the person wouldn't sell to someone of a different race. So suppose you say that photography is expressive. Can you give me your thoughts on a photography business in a shopping mall during this holiday season that offers a product called Scenes with Santa? And this business wants to express its own view of nostalgia about Christmases past by reproducing classic 1940s and 1950s Santa scenes. They do it in sepia tone, and they are customizing each one. This is not off a rack. They're really bringing the people in and having them interact with Santa, children, because they're trying to capture the feelings of a certain era. But precisely because they're trying to capture the feelings of a certain era, their policy is that only white children can be photographed with Santa in this way, because that's how they view the scenes with Santa that they're trying to depict. Now, the business will gladly refer families of color to the Santa at the other end of the mall who'll take anybody, and they will photograph families of color in other scenes. So they're not discriminating against the families. What they're saying is scenes with Santa is preserved for white families, and they want to have a sign next to the Santa that says only white children. Why isn't your argument that they should be able to do that? And maybe it is.
Because in the photograph itself, the objection is not contained in that photograph. But in addition, I think it's important to remind the court that—
No, don't leave. Sorry. What do you mean? I mean, the objection, just like your client's objection, is to expressions that violate their own views of what is being depicted. And so their view of what is being depicted is that a scene with Santa and a child on the lap and all of that in sepia tone, trying to harken back to the good old days, should only have white children in it. That's their firm belief. They are not willing to take photographs of Black, Hispanic, Asian children on Santa's lap. Why is that any different than a situation like this?
Because the specific objection that you're including is not necessarily in that photograph, but even if it were, this court has protected vile, awful, reprehensible, violent speech in the past, and it is never compelled.
No, I'm just asking you, why is the objection of the web designer, as Justice both Kagan and Sotomayor has pointed out, when we look at your examples, they just say things like, please come to the wedding on this day.
Precisely. It's an invitation to a wedding.
Okay, so if my hypothetical is an invitation to join me in the 1950s through looking at this photo, you say one is different?
I say that same clarity of the message isn't in that photo, but there are difficult lines to draw, and that may be an edge case, but this is not. We have a creative—
that may be an edge case.
An edge case.
Yeah. I mean,
in other words, close call. Maybe it could go either way.
Right.
Maybe we could deny Black children sitting on Santa's lap if we're trying to make it look like the 40s and the 50s. It's just, that's my vision.
And think about how this cashes out in the real world, right? If that's an edge case, then the state governments that are charged with enforcing these non-discrimination laws, they are not going to bring actions in those cases because they're afraid they're going to get tangled up in a 10-year-long litigation hellscape. And so the further that the Alliance Defending Freedom and Kirsten Wagner push the court in this direction, the harder it's going to become for any state anywhere to enforce non-discrimination laws, because there's going to be this massive, weird gray area where nobody actually knows if it's legal to discriminate because only the Supreme Court can say for certainty. And so this is an invitation to really, I think, relax enforcement of non-discrimination laws by making it incredibly ambiguous where they cannot actually apply.
If you perceive it as a way of relaxing, I mean, that's the thing, is that the people have to understand these cases do not live in their own little sort of like siloed universes. These cases become building blocks and touchstones and leverage points and pivot points for a whole larger set of cases that are somewhat related to it. That case, and she's talking, as far as that lawyer is concerned, she's saying the case that the hypothetical that KBJ is introducing, the idea that like a Santa Claus in the mall, trying to recreate the 40s when, very unlikely that a Black kid would be sitting on Santa's lap in the mall in the 40s. We can exclude Black people, is an edge case now. If the Supreme Court was to rule in favor of the plaintiffs in this situation, it no longer becomes an edge case there becomes a new edge case that is further out there. Like maybe we just finally get to the restaurant where it's like, when I serve food, it's an expression of love. I'm really creative and I don't want to, do it for two guys who are holding hands when they come in, or black people, or whatever it is.
Yeah, and Alliance Defending Freedom has specific language that they tell their clients to put up in their business so that they can make this argument later. I went back and looked at this individual's website, Lori Smith, through the Wayback Machine. And for some years, she was just a normal website designer, right? ADF, the Alliance Defending Freedom that's representing her, they come along and take her as a client and have her totally rewrite her website to have this big statement about how every single website she designs, every click, every touch of the keyboard is an expression of her personal views that she's trying to communicate to the audience. You can imagine a freaking Olive Garden putting that up on the door, say every breadstick that we serve is an expression of love that communicates our views to our customer. There is no limiting principle here, and I think that's what KBJ so deftly pointed out.
I mean, don't give that work away for free,
Olive
Mark.
Garden, I
please.
feel like probably just stole that.
You need a consulting fee for that.
But so where does her religiosity come into this? Like, I mean, like, is it that, does she need to justify why this is her sort of like thing that she doesn't believe, that she doesn't believe that, despite the fact that it is the law in this country that gay people can get married, she doesn't believe it's real. Does she need to justify that by saying she's religious, or can she just sort of say like,
so
I don't believe it?
In this case, she could really just say, I don't believe it, because this is a free speech case. It was originally both a free speech and a free exercise of religion case, but the Supreme Court only took it up as a free speech case. And so that means the onus, the burdens on her are very relaxed. All she has to do is say, look, there's a message that I want to communicate and a message I don't want to communicate. And I am being forced to communicate the message that I disagree with, and say that by simply providing a template to gay people, she is communicating her message. But ADF wants to make this as easy as possible for them once they're in litigation. Hence the finessed lawyer language that appear on all of their clients' websites and in their stores, explaining how their work, their act of baking a cake or putting together flowers is really an expression of their personal views.
You know, we interviewed, I think it was Susan Mettler on this program years and years ago about the use of First Amendment, not just in these contexts, but also to have businesses get rid of all sorts of types of regulation on them because it's inhibiting their ability to express themselves if they're privately owned. Like, we just don't want to express employees need to wash their hands in the bathroom type of situation, and on and on and on. It makes this incredibly dangerous, because if it's not, if it's not even limited by having a, pre-existing demonstrable religious issue with something, it just becomes, I get to choose whatever I want the rules to society to be, and that's it. Let's play this Sam Alito and this is a fun clip because am I listening to this right? Does he just sort of get like completely owned in some way and then lashes out a little bit, legally speaking? Because it sort of feels like it, that they're just not used to, I don't know, in his right-wing circles, they're just not used to anybody having the answer. And he thinks it's a real gotcha. And yes. All right, that's what I thought. Here is Sam Alito going back and forth. The other voice you'll hear is Justice Elena Kagan. The other man's voice you'll hear is Eric Olson. He is the Colorado Solicitor General.
Then I really will stop. Justice Jackson's example of the Santa in the mall who doesn't want his picture taken with black children. So if there's a black Santa at the other end of the mall and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit, that black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.
And presumably that would be the same Ku Klux Klan outfit, regardless whether the child was black or white or any other characteristic.
Yeah, you do see a lot of black children in Ku Klux Klan outfits, right? All the time. Suppose that, I mean.
That's him That's when he says that about that little comment about you don't see black people in KKK outfits. That's just him trying to run away from his completely sort of like flabby thought experiment there, where he forgot that the whole point about this is that you have people who have constitutional protections because there has been a history of discrimination against these people, and the Constitution says you can't discriminate based upon these grounds. Like, he forgot all of that in his really flabby hypothetical, didn't he?
Yeah, I mean, he forgot the whole premise of the case, which, as you said, is about protected traits, right? Not protected forms of customer expression. Like, it doesn't matter if
like no shirt, no shoes, no service would fall be unconstitutional in this hypothetical.
Exactly. It's just an irrelevant hypothetical. But I want to make the point that one of the reasons there were so many bizarre hypotheticals, because there was the thing about Ashley Madison, there were all these other bizarro questions. Those emerge when there are no actual facts for the court to discuss and to test its legal theories against. So in a previous case, Masterpiece Cake Shop, that involved a baker who discriminated, there was a whole record, right? This guy was sanctioned by the state for discriminating. We saw how the Civil Rights Commission responded. We saw the state's own interpretation of its law. This went through the state court. There was lots for the justices to work with and suss out exactly how this had gone down. Here, this is a fake case, right? I mean, it goes beyond a test case. This woman has never been asked to make a wedding website, and now she's suing for the right not to make them. And so the justices are forced to go down this rabbit hole of increasingly bizarro hypotheticals because they don't have anything real to ask about like they would in a normal case. So they just have to make this stuff up.
Okay, so that begs the question, why are we wasting our time with this? Like, why would the Supreme Court take a case where there are no damages, no facts, like nothing exists? This is like a law school class, right? I mean, like, there's not like no, in law school, you usually will look back on existing cases. Like, this is just made up whole cloth. People sitting around a bar. What if? Like, why is the Supreme Court taking this case?
So my intuition is that it has a lot to do with the reason ADF brought this case in the first place, which is that when this case started in 2016, ADF had a bunch of clients bringing similar claims: the florist, the baker, the photographer, the venue owner, whatever, right? And in each of those cases, the business had actually discriminated against a gay person. And there was an other side of the story. There was a victim who could tell his or her side of the story. And it was like a real compelling narrative between two sides, both of whom had deeply felt beliefs and felt like they were, facing discrimination. Here, of course, this individual never actually discriminated against anyone. And so there's not a sad couple who can be given media interviews to explain how hurt they were when they were turned away. There's not a real victim in this case because it's fake. And that has allowed Lori Smith, the discriminator here, to really become the victim. She has fashioned herself, and her lawyers have fashioned her as the victim of the state's discrimination against her. And because there's no other side, there's no other parties who actually were injured by her conduct, I think the media has really run with that narrative. Go look at how the New York Times, the Wall Street Journal, Washington Post, CNN, AP, look at how all of them covered this case. Big, gauzy photos of Lori Smith in her office, surrounded by Christian aphorisms, super sympathetic interviews, really just biting this line that ADF has given them. And I think that is proof that this strategy has succeeded both in the lower courts and the media, and probably now at SCOTUS.
Wow. And so do you think they're actually going to rule in favor of her? And so now she's not going to have to do what she was never doing in the first place.
Yeah, it'll be really hard for her, right? I think they'll rule in favor of her almost certainly. I mean, the one question is whether there's two conservative justices who can say, maybe bringing fake cases is wrong. Maybe we shouldn't be condoning this. But I think that there's a sense among some of the conservatives like Gorsuch that they already waited so long, right? This was supposed to happen in Masterpiece Cake Shop, but Kennedy kind of backed out and then he retired, and they've already waited like 5 years. So they're not going to let this moment pass them by because they don't know how long they're going to have their supermajority.
And Alito was right. Like, he was trying to make some sort of distinction at another point in oral arguments I was reading between race and sexuality, right? So, like, are they going to try to find some sort of parsing of anti-discrimination laws where potentially they can, I don't know, have it both ways?
I think that's a possibility. I think that Alito's questions are not worth taking too seriously because in situations like this, he's really just trying to own the lawyers who he hates and make fun of the justices who he hates. But yeah, it so much depends on precisely how the decision is written and also whether the court decides to adopt a fake set of facts that promotes its desired theory, like it did last term in the Coach Kennedy case, right? The football coach who was praying at the 50-yard line, the Supreme Court just made stuff up about him to ensure that they could lay down the legal theory that they wanted. I think it's quite possible that could happen here, and Alito is teeing that up.
Let's move to tomorrow's case. With that said, again, all of these things, they're going to be with us. We're going to be citing this fake case in a year or two in the next sort of thing as we erode our civil rights laws in this country. Let's talk about Harper v. Moore, Moore v. Harper. And this is the big case that deals with the independent state legislature doctrine. Just tell us what who's Moore, who's Harper, and then this is really sort of very straightforward description of what's going on here. It is somebody just needs a dictionary on some level, or the originalists really should just do a little bit of history here. But tell us who Harper is in this case.
Moore is a Republican legislative leader in North Carolina. Harper is a voter in North Carolina who sued along with other voters after Moore helped to draw a very, very gerrymandered map for the state's congressional districts. The Republicans, as usual, controlled the North Carolina legislature. They drew an extremely biased map that gave them way more seats than they really deserved. And so these voters sued and said, look, this is a violation of the state constitution. We all know the Supreme Court has said that federal courts can't strike down partisan gerrymanders, right? But the Supreme Court in that same decision told us that state courts certainly had tools at their disposal under state constitutions to try to rein in partisan gerrymandering by themselves. So the North Carolina Supreme Court comes in and says, actually, you know what? Our Constitution goes way beyond the U.S. Constitution. We have this guarantee of free elections. We have these guarantees of freedom of association, of equal voting rights for all. We think that really extreme partisan gerrymanders violate the state constitution. So we're going to strike this one down. The legislature comes back and argues that, in fact, this is the part where we kind of go from like normal to Twilight Zone, argues that state legislatures are not obligated to abide by state constitutions or state courts when they are setting rules for federal elections. So state constitutions, which literally create state legislatures and explain how they make the laws, they cannot tell state legislatures, for instance, you're not allowed to draw an extreme partisan gerrymander. You're not allowed to throw out absentee ballots because of some pointless mistake. Think of all the various rules that govern elections. According to this argument, state legislatures have total control over that. State courts cannot step in. State constitutions are totally irrelevant. And so state legislatures basically get to rig federal elections every single cycle, and there's nothing that state courts can do to stop it.
And also governors. Governors have no power at all to intervene in this as well.
So there's various versions of this theory. There's like the maximalist theory, which is that governors can't intervene. And then there's the more modest theory, which I don't think is actually modest, which is that, well, governors can intervene, but state courts can't because of reasons that no one has been able to articulate. I mean, basically, it's just so radical to say that governors don't have control over lawmaking involving elections that the plaintiffs in this case, or the state legislature in this case, has tried to avoid that issue altogether.
Now, this is all derives from a reading of the U.S. Constitution that says, the Constitution says, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And so, and apparently there's another part of the Constitution that talks about how presidential elections also conducted by the legislature thereof. And so these people are taking that at not even face value. I guess, and saying this means that only the state House members, the Senate and the House or Assembly or however they call them, have power, not the rest of government in the state. And this is just simply a complete misreading of what that word meant at that time that it was written. There was no, the idea that in this unique situation, Congress, the federal government, would empower just one element of state government to do this one thing and can supersede even the state's constitution by empowering somebody else to do it is just, there's no precedent for this whatsoever.
No, there's truly no precedent. I mean, this is radical and literally unprecedented. And to debunk it, you simply have to go back to dictionaries from the 1780s and 1790s and look at how they defined legislature. Today, if you say legislature, sure, you might think about, the state house and state senate in the Capitol. But back then, that is not how the term was used, certainly not exclusively. The legislature was a term of art for the body that makes the laws within a government. It was not one particular organ of government. It was not one particular structured state house. It was the legislative power to create the laws that bind all citizens. And so this idea that when the Constitution says legislature, it really only means these particular state legislatures that we've set up, it's a totally anachronistic reading and very ahistorical. And just to give an analogy, there are a lot of places where the Constitution talks about what powers Congress has. Congress gets to do this, declare war, mint money, regulate commerce, whatever. Nobody says that excludes the president. Nobody says that excludes the federal courts. Nobody says that just because the Constitution talks about Congress alone has that power. It has always been understood that in the many places where the Constitution grants this power to a particular part of government, that it's just trying to grant that power to the lawmaking body that decides how a government is run. And that is just not a novel argument. The Supreme Court has been saying that for a decade. I mean, a century, and it has reaffirmed it in the last decade. And all that's changed since then is that a bunch of conservative justices have joined the court. But this is not an originalist claim that the Republicans are making here. This is an anachronistic claim that is simply designed to hand Republican-controlled state legislatures even more power over federal elections and federal redistricting.
Yeah, I mean, it really feels like saying, well, it says Congress, so you're a senator, not a congressperson. So, yeah, right?
Checkmate.
Yeah. Checkmate.
Checkmate. I mean, or the president tries to veto it, and Congress comes back and says, the Constitution says nothing about the president here. You don't get to do anything. This is all us, baby. That's just not how it works.
You would think if that was anticipated, there would be a notion of, without regard to, you would add a provision without regard to the Constitution of the state, without regard to the governor's veto power, without regard to any other, prior law or referendum or anything like that. But it doesn't.
Right. Judges like to say that as a rule, lawmakers, ratifiers of the Constitution do not hide elephants in mouse holes, that usually a seemingly modest provision or normal provision is not hiding some kind of radical, expansive concept underneath the surface. And I think that applies here really well. Like, if the framers had wanted, in this one instance, I guess two, if you count the presidential elections and congressional elections, if the framers had wanted to exclude other parts of state government, they would have said something. You have to think they would have explained, either at the Constitutional Convention or in the document itself, that they were creating this very narrow rule that only applied in this context to state legislatures as a sort of institution of government. But they didn't do anything like that. And for the last 200 years, we've not functioned like that. We've always understood that, of course, state courts get to interpret state election law. That's like one of the basic rules of federalism. But now we are at a point where 4 justices disagree. And sadly, I mean, this case pretty much comes down to Amy Coney Barrett, which is never a good sign.
Has there ever been, in any writing or contemplation of the U.S. Constitution or subsequent to there, any place where this theory has been offered? Like how recently developed is this theory that in this one instance, when we refer to government, there is a unique power that is associated with a specific cohort of government that exists nowhere else and at no other time except for now?
Right. So here's the one context in which this comes up. Contested House elections in the 1800s, where a state court announces the winner of the election to be person A, but the state legislature announces its belief that the winner is person B. Or the legislature and the courts announce different rules for voting or for counting votes, and those different processes create different winners. And then in that situation, the House has to decide, right? They have control over a contested election. They get to decide who wins. And what we see in some of those instances is that the party that really wants to seat a member of its own party who is favored by the state legislature, they have from time to time raised this argument and said, oh, well, the Constitution just says state legislature. It doesn't talk about state courts. So our guy should be seated because we believe that the state legislature has control here. But the very same people who say that will flip positions as soon as their guy is favored by the state courts instead of the state legislature. So if the guy in their party is picked by the state courts and the state legislature disagrees, they'll suddenly turn around and say, oh, no. Of course state courts have say over this. This has only ever been made as an argument from self-interest from sitting members of Congress who want to seat somebody of their own party. And even that has not been done since the 1800s. So this is not a historical pedigree that the Supreme Court should embrace or consider to be authentic or legitimate.
And again, it comes down to Amy Coney Barrett.
We know that Chief Justice John Roberts is not willing to go here. He held the line during the 2020 election when Kavanaugh, Gorsuch, Alito, and Thomas tried to adopt this theory over the shadow docket, which would have been pretty crazy. So not even having oral arguments or like a case or anything, just saying on October 30th, 2020, that suddenly the independent state legislature theory was the law. Roberts held the line, and I think he will continue to hold the line in this case because, he's not as crazy, basically. He's not willing to totally rewrite the law of this country for a few cases that'll help Republicans. I don't know how Barrett will rule. This is really a test of her originalism, and I don't think she's a very good originalist. She's already deviated from originalist theory time and again when it favors Republicans, especially in voting rights and election cases. So I am not particularly optimistic that Barrett will see the light in this case. And I also don't think she's going to tip her hand during oral arguments because she tends to ask pretty cryptic questions. So we will see what happens. But again, when the future of democracy is in Amy Coney Barrett's hands, it's just not a good sign.
If you're the lawyer defending the idea that, government, the definition of legislature, at least in terms of the way that it was conceived at that time, is the government apparatus to generate laws and to critique laws and to constrain laws, right? I mean, that's what the Constitution does in the state, is it sets up the framework for laws. And so in some way it also develops laws insofar as it gives some type of parameters. Do you just come in with like 4 dictionaries from that time and just go like Exhibit A, Exhibit B, Exhibit C, Exhibit D? Because their whole argument is based upon just this sort of like grade school reading of the words in there. And this just seems like, okay, show and tell time. Here's these dictionaries.
I think what's incredible is that the North Carolina Republicans who brought this case in the first place, who are arguing for this crazy theory, they cited 4 dictionaries from this period in their brief, and 3 of the 4 dictionaries go against them. 3 of the 4 dictionaries that they cite in trying to make this argument go against their theory and talk about a much broader conception of what the legislature is. They found some random dictionary from like New England in the 1800s that seemed to affirm their idea, but the vast body of authority here says otherwise. And what we've seen in this case quite remarkably and I guess I should commend them, a lot of Republicans, a lot of conservatives, lawyers, former judges, even some politicians have come to the Supreme Court through amicus briefs and said, do not do this. Do not go here. What North Carolina Republicans are asking for here is crazy and objectively wrong, and this will beclown the Supreme Court if they adopt this theory. The co-founder of the Federalist Society signed on to one of the meanest amicus briefs I have ever heard, basically saying that anyone who endorses this theory is a kooky idiot. When you have the co-founder of FedSoc saying that, you know something has gone wrong. So maybe Barrett will be amenable to those arguments. But again, I don't know. She's not a very consistent justice. And in the short term, at least, ruling for Republicans here will certainly be more helpful to Republicans than Democrats.
It could be an interesting biopic of that FedSoc guy at the end of this. Mark Joseph Stern, senior writer at Slate, always a pleasure. Thanks for keeping us up on this.
Always a pleasure. Thanks, Sam. Thanks, Emma.
Thanks so much.
All right, folks. That wraps up the first half of the program and means it's time for us to head into the fun half of the program.
Yes.
Did a little bit slow today because somebody yesterday made the point of like, do you think the guests get a little bit irritated when you say, you sign off and then you say, now time for the fun half?
Well, I mean, it is objectively more fun, I think Mark would agree, than talking about how these 9 priests are going to bring about the downfall of our country. I guess not 9, but 6.
I'm not even sure I would agree, actually. I could do that all day.
Oh, yeah. All right. Well,
but
into the fun
own.
half, yes.
Right. Nevertheless, that's what we call it. So that's what we got to keep branding it. Folks, it's your support that makes the show possible. You can become a member at Join the Majority Report.
Existential meltdown.
Yeah, you know.
Well,
what is funny?
I was informed last night by longtime listener Ronald Reagan that we used to call it the better half.
Oh,
early on.
That's worse for the guests.
Early on, like way back in the day, and that Ken Burns, sort of like, I was saying goodbye to Ken Burns. He came on for, I can't remember which I think it was the Central Park 5. He and his daughter did a documentary about that. I can't remember now. And I said better half, and he looked a little bit miffed. So,
yeah. Well, better half, that is like, that's sort of
that's a slap in the face.
Right,
yeah,
right.
That's a genuine.
But it was
better than you.
It was just like a play on where we were trying to develop. We were trying to develop what we call it.
Yeah.
Second half, better half.
Better half. That was a swing and a miss.
Yeah.
It also, like, people think of like spouses when they think of
Right.
better half.
Listen, I don't know. We were playing around. It was probably Michael's idea. I can blame him now. But yeah, Ken Burns never sent me a Christmas card after that.
Yep.
Yep.
They send you one before that?
No.
Okay.
Nope.
But he might have.
But there could have been an opportunity. But
Do you get a lot of Christmas cards from our guests? No. They're like, thanks for having.
No, never gotten a single. I don't get Christmas cards.
Yeah, it might
just
be.
about anybody.
People might think it's strange.
I'm always like shocked when somebody asks me for my address so they can send me a Christmas card. I'm like, but why?
What's your angle here?
Like I see photos of your kids on Instagram. I don't need one in my
I
mailbox.
barely put my family's up.
Yeah.
You put yours up.
I like
Loser.
I actually do get like a couple of those, and I like them. I like them. And
Oh.
I keep them for a long time. I watch the kids grow up. If I like the kids.
Okay. All right. Well,
Folks, again, a reminder, it is your support that's make this show possible. You help this show survive and thrive by becoming a member at jointhemajority.report.com. And when you do, you not only get the free half free of commercials, you also get what we call, with no disrespect to anybody else, the fun half. And where we have fun, it's not to say that we don't have fun with all the other things. And don't forget, if you want to help us with our best ofs, the end of the year, we replay 5 of our best ofs, 6 maybe. And you can send us an email at majorityreporters@gmail.com, and you can choose which ones will be considered the best ofs 2022. And sometimes we even will accept like a December or November, late November of 2021, because we didn't want to use those at the time because they were so close and fresh in people's minds. So send us an email at majorityreporters@gmail.com. Put into the subject line best of. Also, check out our app, majorityapp.com, free iOS, Android. iOS has been updated. Android's happening soon. You can sign up for the AM Quickie through the app at amquickie.com. That's also free. Don't forget, justcoffee.coop, fair trade coffee, tea, or chocolate. Use the coupon code majority, get 10% off. Emma, ESVN.
Yeah, yesterday we spoke a bit about the controversies surrounding Deion Sanders leaving for Colorado, leaving Jackson State. It's an HBCU. What that says overall about the college football system, as well as a little bit of baseball. We talked about DeGrom going to the Rangers, and then just generally our discussion of another crazy week in the NFL. It's always fun every week, gotta say. YouTube.com/ESPN show.
Oh, I timed that well.
Nice.
Matt.
Yeah, tonight at 8 o'clock Eastern Time, Left Reckoning on the Left Reckoning YouTube channel, we have David talking with Ben Case on the DSA and ballot initiatives, and also Kurt Hackbarth talk about Mexico, and we'll do a little post-game stuff. And so that's patreon.com/Left Reckoning to get access to the post-game.
646-257-3920 is the number. Call in. We will take your phone calls.
You are in for it.
All right, folks, 646-257-3920. See you in the fun.
Are you ready?
Who sent us this?
Alpha males are back. Boys back. And the alpha males are back.
Just as delicious as you could imagine.
The alpha males are back. Boys back. And the alpha males are back.
Just want to degrade the white man.
Alpha males are back.
I take all of it in my throat.
Alpha males are back.
Snowflake says what?
The alpha males are back.
You are a madman.
And the alpha males are back.
Oh no, Sam Seder! What a fucking nightmare!
Bring back DJ.
Yeah, or a couple of them. Just put them in rotation.
DJ Denner. Well, the problem with those is they're like 45 seconds long, so I don't know if they're enough of a break.
That's fucking nonsense. See white people doing drugs, they look worse than normal white people, and all white people look disgusting.
And the alpha males,
psych, fuck them. Snowflake says what?